So yes, under this maxim called damnum sine injuria, we have this next important case. So you will see that these are cases more or less of the same nature. Okay, so in this case as well, just like the previous one, Chasemore versus Richards, the facts are almost the same. Okay, so in this case, the defendant, they were miners. They sunk pits on their land. Okay, and when they did that, it drained away the water that flowed under the ground. Okay, but it was also flowing under the property of the plaintiff. Okay, the plaintiff's property was like a mile away. Okay, so due to this digging, the plaintiffs the water from the plaintiff's property had almost dried up. Okay, so just like the earlier cases, these are all almost the same cases that you see. It was held that there is no action, okay, under the law. But let's look at a particular quotation by Justice Tyndall here. Huh? So I will quote the whole thing here. You will find this in your chat box. Okay, just a second. So yes, as you see, Justice Tyndall said here that principle which gives to the owner of the soil all that lies beneath his surface, that the land immediately below is his property, whether it is rock solid or porous ground or venous earth or part soil, part water, that the person who owns the surface may dig therein and apply all that is there found to his own purposes at his free will and pleasure, and that if in the exercise of such right he intercepts or drains off the water collected from underground springs in his neighbor's well, this inconvenience to his neighbor falls within the description of damnum absque injuria, which is nothing but damnum sine injuria, which cannot become the ground of action. So, as you know, under the English law, we see this constant, application of this maxim of damnum sine injuria or damnum esque injuria. But I think one question that was asked to me, okay, although it was not asked, crystal clear way, but it was very relevant question, asked to me. I think when that girl, I don't remember her name, and she said that what about the Water Act 1971? Okay, but I think she meant what about polluting water? Okay, so I can do whatever I want to with the property that I have. So here we are assuming it is landed property, and the maxim says that if you own a land, everything and till the hell and all the way up to heaven belongs to you. And the traditional idea of property, okay, so the traditional definition of property says that, okay, if you own a property, or we can say that the liberal definition of property, okay, as you get in a capitalistic or libertarian world, okay, would say that you can do whatever you want to with your property. So if you're owner of a property, it's completely up to you to do whatsoever you want. Okay, it seems that these cases, judgments that we just studied, seems to be based on that maxim, as we just discussed. Okay, but the thing is that in modern times, in today's time, we do not subscribe to that idea of property. Okay, there are lots of limitations, restrictions that are in fact imposed on the right to property that you have. So even if you own a property, you cannot so use as to create nuisance for your neighbors. Okay, so if you're living in the middle of the city, okay, the local bylaws there may prohibit you from for example keeping pigs there, or maybe making chicken farm, or it might also, as I told you the other day, so there's a brick kiln there, so it's old, but they will not be allowed to open it now because it is prohibited now. Okay, so all those things should also be kept in mind, okay, that you do not as of now have absolute right to your property. So the maxim's application still remains, but it will be subject to what right you still enjoy, okay. That's what will determine how the maxim is applied. So for example, just because someone owns the land does not give that person to, for example, put some dangerous elements, minerals, into the down into the ground, that can pollute the underground water, which can also be extracted by people elsewhere, and then they drink water and then die. And then will your excuse be enough here, that damnum sine injuria, that I did whatever I wanted with the property underground, but it's not my fault that the water carried the poisonous element and someone else drank and suffered, okay. That's definitely not going to be an excuse, okay. So the maxim still applies, but I don't think it applies with the same vigor as it did in the 19th century or early beginnings of the 20th century. Now, with respect to, I hope this is clear. Was my explanation clear to you guys?
Yes, sir.
Yes, sir.
Yes,
This
sir.
is quite
Yes,
a
sir.
simple maxim. One more thing that you guys need to know, okay? So when it comes to this maxim called damnum sine injuria, your motive does not matter, okay. So your motive does not matter whether you did something with good motive or bad motive, does not matter, okay. If your act is not prohibited by the law, if by virtue of your action you do not infringe someone's legal right, okay, so your act will then be subject to the same exception here, that is damnum sine injuria, okay. So whether you dug that well deliberately with full awareness that if you dig well, your neighbor will suffer, that does not make your act illegal here, okay. So we have another very important case, okay. I would easily talk about it elsewhere, but another very important case by the name Bradford Corporation versus Pickles, okay. I'll type it. Okay, so this is another case, okay, of the same sort, okay. So what had happened in this particular case was that, so the Pickles, okay, here he was annoyed at the refusal by a corporation, that is Bradford Corporation. It refused to purchase his land, okay, in connection with a scheme for water supply for the inhabitants of the town. So because it was not taken, so in revenge he dug a shaft, okay, and through that the water which was percolated through his land in unknown and undefined channels from the land of the corporation on a higher level was consequently discolored and diminished when it passed again to the lower land of the corporation. So his land was strategically placed, okay, so he dug a shaft, so it diminished it reduced, or it affected the quality of the water that flowed to the lower land of the corporation, and it affected their water supply plans, okay. Now when the matter was taken to the court was to decide whether his act raised some cause of action in favor of Bradford Corporation. Again, as you know clearly from the fact of the case that Pickles here, he deliberately, with full intention and motive, whatever you call it, okay, dug that shaft so as to interfere the flow of water, okay. But court held that there was no cause of action. So if your action is legally permitted, and if your action does not violate someone's legal right, okay, so it does not matter with what motive you did your act, okay, there will be no cause of action, so as the maxim says, okay. So I hope this maxim is now crystal clear to you guys.
Yes.
Huh?
Yes, sir.
Yes,
So,
yes, Arnab, tell me.
so like you just said that Pickles person dug a shaft on his land.
Okay.
So does not it violate Bradford Corporation right to have the water?
So
Like if he dug the shaft on his land, or most of the water will come on that part of his land. So how the Bradford Corporation will work if such type of things happen.
Yeah, so that's the thing. So I wasn't judging. So as I told you so far, I was not judging the merit of the decision. Okay, but here's what they probably did. So for example, you think of it as your own case. Okay, so you own a piece of land. Okay, and it says that if you own a piece of land, you can do whatever you want to with it. So that includes you extracting water from under the soil. Okay, and your neighbors also have the same expectation. Okay, now for example, the water flows from the direction of your property to your neighbor's property. Now because you dug a well, okay, it led to less water flowing into your neighbor's soil. Okay, and your neighbor raises this question that that flow of water got affected because you dug a well on your own land. Okay, then the matter is taken to court. The court is to decide whether you are liable or not. So as I told you, every decision is based on certain legal principle. Okay, certain legal principle. Without a legal principle, no decision is given. Even when you look at a statute, even statutes are based on certain principles. Okay, so here the principle is, let me tell you guys the maxim. Okay, it says casus est solam ius. Okay, est asc ad colium et ad inferos. Okay, Latin maxim, I will type it. I'm sorry, I'm torturing you guys with lots of Latin here, huh? So you can see I've typed it there. Okay, casus, or you can also pronounce as caius or whatever. Okay, casus est solam ius est asc ad colium et ad inferos. Okay, so whoever owns the land, okay, owns up to the hells below and up to the up to all the way up to the heavens. Okay, so this is a common law maxim. Okay, common law belief. Okay, that if you own a particular piece of land, everything all the way to the ground, okay, and all the way up to the heavens belongs to you. And you can do another maxim that is there, the libertarian or liberal idea of property, that says that you can do whatever you want to with the property. All these decisions where you can see predicated less on this damnum sine injuria and more on those principles, as you can clearly see. Okay, so yes, damnum sine injuria is applicable, but when they say that there is damage without injury of right, okay, legal right, how are they defining, okay, what right I own or what right I do not? Okay, that they developed based on certain other underlying principle, like the ones I just mentioned you. Okay, so their idea, their presumption was that you can do whatever you want to with your land. So you can also dig a trench, you can also dig a shaft, you can do whatever you want to. Now if your act on your own land interferes the flow of water, then you have done nothing wrong here. Okay, that's how they have decided. But as I told you, okay, here also there is question of law of property here, okay, that I do not want to go at this stage. Okay, usually we discuss all these topics, all these concepts in the in law of property, in property, jurisprudence of property. But unfortunately, because you guys have entered under a different scheme, I think you do not have conceptual jurisprudence, you merely have theoretical jurisprudence. So I don't know if I'll be able to discuss those later on. But for now, let me just tell you this, that whenever a decision is given, the decision is based on certain principles. The principle here is that whoever owns a land can do whatever they want to. So if that is the principle, this is naturally the outcome that the judges will arrive at. But as I told you at the beginning, that that we have to take all these with a word of caution. I gave you guys the example of Nestle or Coca-Cola, whatever. Okay, I told you that this maxim will probably not be applicable to its extreme extent. It will not be. Okay, some kind of restrictions are imposed, and those restrictions are legal restrictions which are imposed. So I think for domestic purposes, such restrictions will not be imposed, but other regulations could be there that will depend on where you are, that might impose certain restrictions on unrestrained commercial exploitation that can lead to someone else's rights being violated. But the idea.
Sir,
Okay.
is
Yes.
this Latin maxim still in effect, or there are certain restrictions upon the usage of land?
So
Because
obviously there are restrictions. So for example, you cannot use your land so as to pollute in whatever way you want, can you?
no, not in that way.
Then
Like if I dig my land and I find gold within,
okay, yes, interesting. Yeah, to that extent, that is definitely there. So yes, whatever is under the ground belongs to you. Okay, to that extent, the maxim is definitely there. We will talk about it in jurisprudence if I'm teaching this subject to you. So as you said, there are many cases. Okay, so another idea here is that a thing that belongs to no one. Okay, whoever is the first to find it, it will belong to them. So your landed, and I think the case of gold that you are referring to, it belongs to you because it's under the property that belongs to you. It's as simple as that. Anyway,
So,
yes,
sir,
yes,
sir,
yes, yes.
so, but I,
if lots of gold, then ton of gold found
So
under the
yes, I think
ground.
we have to, give it to government.
see, let me tell you, whether you have to give it to government or not will depend on what the law of the land says. Okay, if the law of the land says that if mineral of certain quantity is found, okay, and then it belongs to the government, then you can say that yes. But if it is not there, whatever the maxim that I read to you is the one that is applicable. So for example, when I was referring to that quotation from the judgment little while ago in Acton versus Blundell. Okay, so what does it says? Whether it is solid rock, porous ground, or venous earth. Okay, so what does venous earth mean? It's veinous earth in which you get minerals. Okay, deposits. Okay, if it is in your land, then it belongs to you. That's the common law. Okay, that's the basics of the law. But if, and you say that more is found, okay, more than just a few gold coins are found, okay, who does it belong to? That depends on what the laws of the land says. Okay, enacted laws of the land says. Okay, we follow common law, so the maxim applies to us. Whatever is found underground belongs to you. But if a law says that, okay, if something of certain quantity is found, then it belongs to the state, then that will be applicable because legislation will be superior to common law. But so far, I do not know of any specific law that says so, but it could be there. I plead my ignorance, but I do not know of any such law as of yet. Is that fine? But you understand how it works, don't you?
Yes,
So
sir.
basically, we have to see at the entire plethora of laws that are
Yes, you have to.
applicable in the land.
Yes. You
We
have
can't
to.
just use it in an
No,
isolated manner.
no. But you have to understand the order in which the law works. Okay, the fundamental
Yes,
idea is that whatever is below the ground belongs to you.
yes, sir.
Okay, or similar maxims could be there elsewhere. So, for example, if you are the first one to find something, then it belongs to you. That is also based on a certain maxim. Okay,
Yes, sir.
called res nullius. So all those maxims are there. Okay, but then over and above the legal system you are part of could impose restrictions. Okay, that's essentially the idea. So for example, why was I referring to pollution? Because a few hundred years ago no such regulations existed, so you could do whatever you wanted with your property. Okay, that was based on a particular theory of property, but as of now it does not work like that. Okay, we do not subscribe to the same idea of property. Anyway, I'm digressing from the topic here. So I hope the maxim of damnum sine injuria is clear to you.
Yes, sir.
Okay.
Yes, sir.
But all I wanted to tell you is that beneath all the maxims, all the case laws, judgments that you study, there is also a sub layer of certain accepted principles, beliefs, faiths, ideologies are there. And as a law student, okay, as a not just you're not just ordinary law students, you are better than other law students, so you have to be able to look at that as well. That's why I go beyond the what is written in the book and tell you guys about what else is there. So anyway,
Uh,
yes, yes,
Sir, can I ask some question? Like it is much can be weird, sir, if
yes,
you
tell me,
permit.
tell me.
Sir, suppose I find a painting or a statue which is very sacred for a certain religion.
Haha.
So can I claim that statue as my personal property or will it be a government property as it belongs to religion?
So see, now does religion belong to government?
No, sir. Like suppose
See,
might be sir, like in
no, no,
pressure or
see, the thing is, here's what will happen. So for example, you find a very costly gold statue, okay, of some god that someone believes in, okay. The thing is that from the nature of the statue itself, we can assume that okay, it probably belongs to someone, okay. So before you get to keep it for yourself, in the following the doctrine of res nullius, or finders keepers, whatever, okay, before you keep it to yourself, assuming that, okay, you also have to find out whether it belongs to someone else, okay. Unjust enrichment, remember we discussed few days ago, okay. So if it does not belong to anyone else, then you get to keep it. Now, whether you get to keep it or not, okay, will also after that depend on what the law of the land says, okay. I don't think that the state can, just like that, lay claim to what you find, okay. It cannot just do that without validation of any law. That's essentially the idea, okay. So
Would the
yes,
same maxim be applicable for the gold? If I try to find the owner and I don't
yes, no,
sorry,
see, the thing
if
is,
I find the
depends.
gold, do I have to try to find the owner for it
See,
before
it's,
I get to keep it?
yeah, usually that's the case, okay. But in common law, the idea is that in the absence of a better claim, you have the best claim, okay. The moment someone has a better claim, then your claim is subordinate to that better claim, okay. That's essentially the idea. But anyway, we are digressing. We are not talking about law of tort, okay. We will discuss this in property later on. We will discuss about that, okay. I'm sorry, but we have very little time, and we have to finish this syllabus as well. So I'm sorry, I will answer this, but at an appropriate time. Now I hope this is clear, okay. So far we discussed two different elements of law of tort, okay. So first we looked at the wrongful act, then we looked at legal damage, okay. And then okay, here's one more thing. There are certain wrongs in which mere token damage is not sufficient. You also need certain kind of special damages, okay. So you need some kind of actual harm or actual loss for any remedy to be there, okay. So those are, for example, negligence, okay, nuisance, nuisance that causes damage to your property, okay, slander, deceit, etc. So there are certain exceptional torts that we will discuss in greater detail, don't worry. In those cases you need special damage for a claim, okay. Now apart from that, the third important element that that is there in tort is a legal remedy, okay. So if all these two things are there, okay, then the third element is legal remedy, okay. Now as you know that not all civil remedies, civil injuries are tort, okay. But those civil injuries, okay, in which you have a civil action for damages, okay, those are only known as tort, okay. Now as you know, in there is something called law of limitations, okay. So quite often what happens is that law of limitation lays down essentially the period within which you are to institute a suit, okay, in the court of law. We will discuss this in greater detail later on, okay. Now law of limitation lays down certain period within which you are to institute a suit, okay. Now the thing is, if you do not institute your suit, okay, within that period of time, then what happens? Does your right end? No, it merely becomes from perfect to imperfect right. That means you can no longer enforce it in the court of law, but for every other purpose the right still remains, okay. So in this specific situation, it seems that, okay, you do not have a cause of action, okay, a civil action for damages, okay. But then so that's why you cannot say that mere absence of damage will conclusively tell you that, okay, it is not a case of tort. It could be the case that you had a cause of action, but the law of limitation, the limitation period has ended. Okay, for example, under the in India's case, you have Limitation Act 1963. You have to look at that. Okay, look at the nature of the suit, and then you will see what is the limitation period. So if you fail to institute the suit within that period of time, now you do not have a cause of action. So and then you do not get legal damages. So will you say that this is not a matter of tort? That's not the case. Okay, so that's why we say that legal damages, or whether you have legal remedy, okay, a civil action for damages is there or not, definitely tells you that whether it is a matter of tort or not. Okay, but it is not conclusive. That much you need to keep in mind. So yes, I hope so far whatever we discussed is clear to you about tort. Okay.
Yes, sir.
Okay.
Can you just repeat the remedy part? I didn't really get it.
So I'll explain that again. Okay. So what's the first element that we discussed of tort? It's wrongful act, isn't it? Wrongful act. Okay. So a wrongful act that gives you legal damage. Okay, so we discussed the two different maxims. Okay, now in tort there is a very important element that makes it tort. Okay, there are many different kinds of civil injuries. Okay, but not all civil injuries are considered as tort. So which civil injuries are considered as tort? The ones in which there is a only those for which there is a civil action for damages. Okay, that it's unliquidated damages is available. If it is of that sort, then it is a case of tort. So if you do not have legal remedy, then there is no legal wrong, so it is not a case of tort. But I'm telling you that there could arise a situation in which you do not have a legal remedy, okay, but it is still a tort, okay, which goes contrary to what I just told you. So that situation is what I was trying to tell you. Okay, it is possible very much that a situation arises in which you do not have a legal remedy. Okay, even then it is a matter of tort. So when could that arise? So I was telling you about the law of limitation. Law of limitation essentially it says that on a particular matter, what is the limitation period within which you are to institute a suit. Okay, so if you exceed that limitation period, you cannot institute a suit. Okay, so you do not have a remedy under the law, but that does not mean that you did not have a right. You had a right. Okay, so that means there was still a matter of tort. It's just that it's no longer can be taken. It can no longer be taken as a cause of action anymore. That's what I wanted to tell you. Is that clear to you? So limitations essentially an exception to this. Okay, that's it. So I hope this is clear. It's quite easy. Okay, so I would like to tell you guys one more thing at this stage, that just so that you guys remember, okay, that there are two approaches to this question of liability. Okay, one says that there is general principle of liability, and the other one says that there are specific cases of liability. So that's the distinction that we had made earlier between Salmon's approach on the one hand and Winfield's approach on the other end. Salmon, who says that because earlier in England there were specific forms of action, and then there were limited number of cases in which you could institute a suit. Okay, based on that, Salmon's view was that there were no general principle of liability. Okay, so the principle of liability is not unending. There were limited number of cases in which liabilities arise. On the other hand, contrary to that, Winfield says that no, the principle of liability keeps increasing. For example, the law of negligence, it just keeps increasing. Okay, newer and newer cases are recognized in which cause of action is recognized in case of negligence. So if rights are increasing like that, okay, so it seems that there is a general principle of liability. Sorry, I have to take the call. Just a second. Hello? Oh, my God. This class hota hai. Come. Hi. Oh, just a second. एक So yes, I'm sorry for the interference. Okay, so that's essentially what tort is all about. Okay, so apart from this, okay, there are certain other general elements in tort that you should know, that you already know. So just introductory, a little bit here and there. Okay, some other elements are so acts and omission are elements of tort. Okay, but the thing is that acts and omissions are not in itself are problematic. Okay, your acts and omission should be in violation of certain rights. Okay, now when can we say that there is a right? Okay, when can we say that there is no right? Okay, now I think this is very problematic, in the sense that in the light of the fact situation, the judges will determine whether you have there was a right that your act violated, or your forbearance or your abstinence, okay, violated. Okay, so for example, you do not have a duty to help a beggar, so there will be no cause of action if you fail to help someone who's in need. Okay, there is no cause of action if someone who is drowning, you did not jump into the water to save that person. Okay, but then again, it will vary from legal systems to legal systems. If you were in a hardcore socialistic legal system, then there is a duty of assistance as well. You find someone in distress, you have a legal duty to save that person, but that's not the case in our legal system. But so if someone who's in trouble, okay, who's in distress, okay, and you voluntarily start a rescue, but halfway through you stop it, then it is possible that you have violated, you had a duty to rescue that person, now that you have voluntarily put yourself in that position. Okay, so yes, so for example, another example in the book that has been given is that if you own a piece of land adjacent to someone else's land, okay, and there is some wild growth on your land, okay, and you being the owner, okay, you are the only person who can control the wild growth. Okay, but you do not do that. Okay, and it affects your neighbor's property as well. In such case, even though otherwise we wouldn't assume that you have such a duty to control such growth, but in such situation it is very possible that you have a right to prevent such growth. So it's difficult for me in advance to say which act situations or or omissions will lead to creation, violation of a right or impose a duty, but it can arise, and it is for the judge to determine. Okay, so next important element is whether your action or omission that we discussed should be voluntary or involuntary. Now what does now you will see that in tort, okay, the words convey confusing meanings. Okay, so when we say voluntarily, you assume that it has been done deliberately. So you deliberately, without any justification, enter or trespass into someone's property, it is considered as a voluntary act. So it leads to cause of action. But someone's, okay, you are in grave danger. So okay, so the only way you could avoid it is by entering into someone's property, and you did that. In such case, there'll be no cause of action here. Okay, or you will have no liability here. So yes, that is another important element, but these are not to be generalized. Okay, then there is something called malice. Okay, malice generally we understand to be something of ill will. Okay, so when you possess ill will towards someone else. Okay, but malice again has two different kinds. One is malice in fact, and the other one is malice in law. Okay, so malice in fact is essentially ill will, as I told you, and malice in law is little different. Okay, it is not necessarily you having ill will. It is rather to be equated with the idea of motive. Okay, so these two things need to be looked at. Okay, but as you know, the motive in itself, okay, the motive in itself will not be sufficient, okay, unless, okay, there is a violation of someone's legal right, okay. So malice in itself, okay, is not enough. It has to be malice in law, okay. So yes, that's and then there has to be injury of right, okay. So that's the idea of malice. And then there are other elements as well, okay. Negligence in itself is a tort, okay. Negligence in itself is a tort, but negligence is also a mental element, okay. Negligence is when you do not take reasonable care in doing something that you should do, okay. So one would say that, the reasonable care that a reasonable person should take, okay. Then comes the question of what is a reasonable person. Now defining reasonable person is again problematic. Earlier we used to use the words reasonable man, and now we use reasonable person to make it gender neutral. And yes, there was in fact a problem with using the idea of reasonable man, because the idea of reasonable man was in fact a depiction of a man being reasonable. But then a reasonable person again is not an ordinary person, because ordinary people do lots of stupid things, okay. They are negligent quite often. So being ordinary will not be an excuse. So you have to take reasonable care, okay. So yes, negligence is another important element here. I'm not going to talk about intention and motive at this stage. We will discuss about that later. So I will just talk about one last element. We do not have time, so I just want to complete it for today. One last element that I want to talk about is fault, okay. Now what is the importance of fault? As I said, okay, in tort you are essentially made to compensate someone for a wrong, okay, that is based on your own fault, okay. Whatever the wrong that you have done, okay, whatever the civil wrong you have committed, okay, it is your own fault. Because it is your own fault, you are made to compensate the other, okay. Now that was essentially the understanding of law tort, okay, the fault based liability. But as of today, okay, we have ventured much beyond this idea of fault. So there are very much possibility of cases in which you are at no fault, but you are nonetheless made to compensate the other party. So those are cases of strict liability in which you have certain exceptions. But in India there is a new idea that has been created of that of fault, known as absolute liability, in which fault does not play any role in whether you are liable or not, okay. I'm not going to go into discussions of all that, but the two important cases with respect to fault, liability without fault is Rylance versus Fletcher and the case of MC Mehta versus Union of India. These are the two cases that we will discuss later on in greater detail, okay. So anyway, these are the other general elements of tort. So with that, I would like to end our discussion for today.